connecting pretty much the whole of the world. Endport will be in Rotterdam, and it's going to be financed by private companies, development banks, the Chinese banks themselves. The Chinese have set up 2 new development banks, which are funded by BRICS states, and they will have a private finance mandate. There'll be a variety of assets, roads, rail, pipelines, and this is a really good example, I think, of the phenomenon of development projects, their transnational spread, and also the actors that are going to be involved in this. Private actors, multilateral actors, financial institutions, and of course communities. Now, a lot of the states along this route will of course have human rights obligations. It's not clear how the Chinese will deal with them in terms of transparency. The contracts, projects, management plans haven't been disclosed. How will states work, and also institutions like the World Bank, when they won't be providing the lion's share of the funding in this? How will they deal with the power asymmetries in negotiation? Will human rights be negotiated out or diluted out? Where will the communities go to access remedies? Will the financiers see their role as too remote in all of this? Of course, there's supply chain issues as well. They're providing goods and services, raw materials along various routes. So, how will that work? Labour rights. And, yeah, I think that's gives a pretty good flavour of the actors and some of the issues that we'll hopefully talk about today. Okay.
I just wanted to mention one thing that's also important for our panelists today. We have a camera, and there's cameras, and these sessions are being recorded. Yesterday everybody was fine with that, but we do want to stress that if you feel uncomfortable with being recorded, please tell us, and we should have actually, apologies to this panel that it comes so late, but if you have a problem with that, you think some parts should not be recorded, please let us know, and we can just switch off the camera for that part. Okay. Now I'm looking around the room because I'm missing someone. Nathaniel. We'll show the video and then briefly introduce that. No sound. Okay. Yeah.
A mountain they revere as a god, and a multinational mining company with its sights set on the mountain's sacred stone. The stage is set for a bitter struggle against the backdrop of eastern India's dramatic landscapes. As the bulldozers draw closer, what will one tribe do to save their forest, their mountains, and their god?
I think I want to ask Kinnari to introduce it because you actually thought of this example.
Okay, so this is, it's 2009. It was a community activism project with the Vedanta, a very powerful Indian mining company, who may be now delisted from the London Stock Exchange, if you've been following the UK news. So this involved a tribal community in India, where it's a good point here about access to justice, I think, to cut a long story short. So we've got Joanna Lumley, we've got Survival International, who are a really prominent NGO in the UK working on tribal rights. And here you've got really interesting tensions, obviously, between property rights of a private developer, pitted against traditional customary rights of communities. You've got constitutional contestations as well in India because scheduled tribes do have constitutional protection. How far does that go? Where do the limits to that end? How far can private companies come in and extract? In this case, you had a successful Supreme Court judgment which ruled that Vedanta had to stop mining, but the result of that was brought about by this kind of campaign, right? So, and we all know now, how many of these kinds of projects are happening routinely on a daily basis. So, it's a quite interesting story about, how easy it is for groups that are having these kinds of injustices to mobilise their rights, and even when there is a constitution that ostensibly would protect them in the face of private power. Yeah.
Thank you, Kinnery. Karin, I think I can turn over to you. For the first panel, I'll put this mic here. Right?
Yep. Okay. Thank you very much, Sanne and Kinnery. Is the microphone working? Okay. My name is Karin Arts. I'm Professor of International Law and Development here at ISS. And of course very happy to chair this interesting panel, which will give us a very diverse range of perspectives on issues relating to corporate social responsibility, or more broadly, the role of corporate actors. The procedure will be as follows. We will start with 4 presentations, 15 minutes each. After that, we have Professor Ellen Hague of Erasmus School of Law, who as a discussant will kickstart the exchange about the presentations. After that, the panelists have a very short opportunity to give a first reaction to Ellen's comments, and then we turn to the audience, and we hope to have a lively exchange with all of you. Without further ado, I give the floor now to Lisbeth Enneking, also professor at the Erasmus School of Law, who will present her paper on corporate accountability for irresponsible business conduct in global value change.
Thank you very much. Thank you also very much for the invitation. For me, it's a bit, somehow I felt it as a bit of a challenge to talk in front of an audience that to me is a human rights audience, because I'm not a human rights lawyer myself. I am a legal scholar, but I'm a private law legal scholar, and so this has a lot to do with the issue that the question that I would like to pose to you also today. Whether I think sometimes we look at similar cases, similar problems in a different way, and the question is whether that is justified, that we look at it in different ways, or whether we should try to adopt and understand each other's way of looking at these cases in a better way. This will come back at the end of my presentation. What I want to start with, and I'm just going to see if is this image. And I think to many of you, this may be a familiar image. If not, no problem, because this is what I'm going to be talking about just now. I'd like to start with the fact that in June 2017, and people from the Netherlands will know probably, a civil liability suit was filed before the Hague District Court against Shell for its alleged involvements in human rights violations perpetrated in Nigeria in the mid-1990s. The case was filed by relatives of a number of Nigerian environmental activists who had been illegally detained, tortured and killed by the Nigerian military regime of the time. And the plaintiffs in this case seek to hold the defendant companies liable for complicity with the human rights violations that have been perpetrated so by the Nigerian government. And they claim that the defendants have provided, for instance, transport to Nigerian troops, that they allowed company property to be used as staging areas for attacks against the locals, and that they even provided food to the soldiers and paid them. And so basically they say that this makes the company complicit in human rights violations that were perpetrated by the Nigerian regime. They base their claims, in this case, on a cause of action under domestic Nigerian law that makes it possible to file a liability claim against both natural and legal persons, which is important, for complicity in human rights violations. And on the basis of this provision, they claim both compensatory and punitive damages, as well as a public apology. So this case only just started in the Netherlands. The only thing I've seen is the statement of claim. I don't think the defendants have even responded yet. So this is an ongoing case here and very new, but it's not a case that comes out of nowhere. Because it is very closely connected to 2 cases that have made their way through the US court system between 1996 and 2013. And the first of these cases was filed in November 1996, so a little bit over 20 years ago now already. And this was a civil liability suit that was filed before a federal district court in New York against 2 Shell holding companies and their Nigerian subsidiary by different plaintiffs, but in relation to the same events. And these plaintiffs based their claims on the Alien Tort Statute. which is an old and relatively obscure US federal statute that has been rediscovered in the 1980s as providing a basis for civil liability claims, to bring civil liability claims before US federal courts in relation to international human rights violations perpetrated anywhere in the world. So this WIBA case that was initiated in 1996 on this basis was dismissed 2 years later in 1998 by the district court, which held, not on the basis of any considerations relating to the Alien Tort Statute, but the court had basically held that the case had so few connections to the US legal order, since it was brought by non-US plaintiffs, Nigerians, against the non-US defendants, as Shell is an Anglo-Dutch company, for violations that had taken place outside of the US, in Nigeria, that the case had so few connections to the US legal order that it could more conveniently be tried, for instance, in England or the Netherlands, where the companies had their home base. This decision by the district court was reversed, however, 2 years later by the Court of Appeals for the Second Circuit, which found that, in contrast to what the district court thought, that the case did have sufficient context to the New York Forum for the court to assume personal jurisdiction over the plaintiffs. And I think what's interesting about this verdict, many things, but one of the things that are interesting is that the court also considered that the US had an interest in furnishing a forum to litigate claims dealing with violations of international human rights standards. This case was eventually settled out of court in 2009 for $15.5 million, but this did not mean the end of the legal sort of troubles of Shell in relation to these events in Nigeria in the mid-1990s. Because in 2002, a very similar set of claims had been filed against Shell before the same court in New York, but by a different group of plaintiffs. And this case, in a legal sense, just went a completely different way, as the case started to revolve not so much about the issue of personal jurisdiction or the context to the U.S. legal, to the New York Forum, but it started to revolve around the scope and interpretation of the legal basis for the claims, the Alien Tort Statute. And in 2010, and I'm taking major leaps here, but with a view to the time, in 2010, the Second Circuit Court of Appeals came up with a very important decision, as it held that since, according to the court, corporate actors are not liable under customary international law for violations of international human rights norms, they could also not be held liable for such violations on the basis of the Alien Tort Statute. So basically, you could have filed this claim against an individual perpetrator perhaps, but not against a corporation, because corporations do not have any direct obligations under international law to respect the human rights of others. That's basically what the Second Circuit Court of Appeals said. Obviously, the plaintiffs were not so happy with this decision, and they filed an appeal to the Supreme Court, which accepted to review the case. And in 2013, the Supreme Court came with a very important judgment, in which it actually did not go into this whole issue of liability under international law of legal persons. But it actually came up with a decision in which it said this legal basis, the Alien Tort Statute, can only provide a legal basis for claims that relate to violations of international human rights norms that have taken place outside of the United States, if those claims touch and concern the territory of the United States with sufficient force. So the court went into a completely different issue in relation to these cases, and it went into an issue that actually is more related to what the WIWA case was all about, the fact that these cases have only very few connections to the US legal order. And it said basically that a case like this has so few connections to the legal order of the United States that it cannot be pursued there on the basis of the Alien Tort Statute. Still, this decision, as we know now, did not put an end to the legal troubles of Shell in respect to these events that happened in Nigeria in the mid-1990s, because the same plaintiffs that filed this Kiobel case in the US refiled their case basically now in the Netherlands. It's a new case. It's based on a different legal basis, obviously, because here you cannot file, we don't have an Alien Tort Statute-like statute in the Netherlands, nor do they have one in Nigeria. So a lot is different, but still the plaintiffs are, and this is very important, relying on many of the documents that were generated in the course of those 20 years of proceedings before US courts. And this is, US courts, there has been a case already in US courts in which they have requested those documents and those have been granted to them. That has been an important victory, although there is now an appeal pending, obviously because Shell is not so happy about, because this would make life much more easier for the plaintiffs in this new case. If we look at these cases from a human rights scholar's perspective, the focus automatically turns to the legal basis of these US claims, the Alien Tort Statute. And this is basically what has happened in the scholarly debate over these cases over the past few decades. There has been a lot of focus on this Alien Tort Statute and on the human, which is a statute that only allows claims based on alleged violations of international human rights norms. So it necessitates a focus on a framing of these cases as human rights related cases. This has generated a lot of interesting cases, a lot of interesting debates. In fact, by 2009, some 156 cases had been pursued on the basis of the Alien Tort Statute against corporate actors before US courts. But in recent years, and this has already been going on for quite some time, US courts have become worried about basically the economic implications, the trade implications, the foreign relations implications of these cases against these corporate actors on this sort of, relatively shaky legal basis, being a 1789 statute that no one ever really understood. So what they've started to do, and they've successfully started to do, is to close the door to this type of litigation. And there have been a succession of Supreme Court judgments in which it has been made more and more and more difficult to bring these cases on this legal basis of the Alien Tort Statute. And I think this is, in a sense, regrettable because as we see that the legal opportunities for bringing this type of litigation, at least in the US, on the basis of this statute that allows this human rights framing of these cases, the scope there is getting narrower. What we see, on the other hand, in the societal debate is that the societal debate on business and human rights has been growing much more fierce over the past decade, especially with the coming out of the UN Guiding Principles on Business and Human Rights. So that we see two different sort of movements there. I already said I'm not a human rights scholar, but I'm a private law scholar, and as such I look at these cases in a bit of a different way. Because if we abandon sort of the human rights, the focus on the human rights aspects of these cases that has been so prevalent in the discussion, in the scholarly debate, the picture actually becomes one of a more general international trend towards transnational civil liability cases before courts in Western societies in relation to irresponsible business conduct in global value chains. And although the majority of these cases, of this trend that I'm talking about, this trend towards foreign direct liability cases, the majority of these cases have been pursued in the US on the basis of the Alien Tort Statute, we actually in recent decades see more and more and more of these cases being pursued in different Western societies like Canada, France, the UK, Germany, the Netherlands, etc., etc., etc. And have different from their US counterparts, what we also see is that these non-US cases generally do not focus on corporate accountability for violations of human rights norms, but focus on corporate accountability for violations of labor norms, environmental norms, and health and safety norms. So basically there you see that this human rights framing is actually increasingly abandoned. And this is, of course, also connected to the fact that this Alien Tort Statute that we had in the US, or that we still have in the US, we do not have in any other society, so that everyone needs to make do with what is there. And basically what has been happening is that these cases outside of the US are usually filed on the basis of general principles of tort law, and the tort of negligence in particular. So then the central question in these cases is not anymore one of complicity in human rights violations, but it's a question of whether and to what extent the company may, under certain circumstances, owe a duty of care towards workers, neighbors, and communities that stand to suffer harm as a result of the company's activities in a host country. Because of this sort of shift in focus in these cases, what is also interesting is that the sort of societal background to these cases also becomes a broader one. So we're not looking anymore only to have developments in the business human rights fields, but we're also thinking about more general discussions on corporate social responsibility, on sustainability, on responsible business conduct. And this opens up a much broader scope of societal debate that these cases basically have a place in. I'm actually coming to the point that I want to make now, or the question that I would like to raise. From my perspective as a private law scholar, I really doubt whether it's useful, as has been happening so much, to make a distinction between the human rights related cases on the one hand and the non-human rights related cases on the other hand, when we are looking at the issue of accountability of internationally operating business enterprises for irresponsible business conduct and global value chains. I think we're basically looking really at the same thing, because the backgrounds to these cases, whether they're framed as human rights cases like they have been in the US or not as human rights cases as they have been elsewhere, are all the same, are very similar. The issues that these cases seek to address are very similar. These are all about situations where individuals, workers, communities from countries in the global south turn to courts in the global north in order to obtain a higher level of protection of their human rights, of their environmental, their labor, and their health and safety related interests than is afforded to them by local rules in the countries where they reside. And I suppose in the end, the actual question in all of these cases is whether it's acceptable that these local individuals, workers and communities in the global south are left with the bill of the corporate activities that generate the prosperity of us living in the global north. So the context within which I think we should frame these cases is a very broad one that doesn't necessarily require a distinction between human rights or non-human rights. At the same time, and I think this is also an important point, the legal feasibility of these cases is to a large extent determined by factors that are similar in all of these cases. These are basically 4 factors that determine whether these cases are feasible. First one is, does the court seize the matter have jurisdiction to hear the claim? Secondly, which law should the court apply? This is an important question in these transnational cases. Should it be the law of the host country or that of the home country or international law? Then third question, what is the legal basis that these claims can be based on, and what are the accompanying requirements for a liability that are related to this legal basis? And the fourth question is, to what extent do procedural circumstances in the countries where the cases are brought, and these may include possibilities to finance the pursuit of litigation, the possibilities to file collective actions, and the possibilities to get access to evidence that is in the hands of your corporate opponents, whether these procedural circumstances create thresholds that prevent the successful pursuit of litigation. And if we look at these 4 factors, you actually see that the first, second, and fourth are will be answered in exactly the same way, regardless of how the case is actually framed. And if we look at the third factor, the legal basis for these claims, what we see is that actually, if we look at that litigation that has been going on in the US, the framing as human rights cases, or the fact that they have been based on the Alien Tort Statute, is actually, it has opened doors, but at the same time, it has made things much more difficult, because of these 156 cases, and it's more now, only very few, and if I'd say very few, it's 2 or something, have actually reached a decision. A court decision has been reached on the merits in which the company was actually held, liable for complicity with human rights violations. So, also, I think the focus on the Alien Tort Statute and the human rights requirements related to the Alien Tort Statute obscures, perhaps, what we're actually talking about here. So my question then would also be, and that's my last question, going perhaps even a little bit further, is there any added value even to framing these cases in this context as human rights related cases? And I hope you're all now going to tell me that I'm completely stupid and that there is value. So as I said, the ATS example shows that, well, it hasn't always been very helpful and even perhaps added extra problems. And I think what's also telling is that of the cases that have been filed outside of the US, very, very few of them have been framed as human rights cases. So obviously there, I suppose, whether it was a question of, probably as out of a question of legal pragmatism, the people bringing them have decided not to, you know, walk the path of framing them as human rights related cases. However, on the other hand, and I think this is also important to recognize, is that the objectives behind the pursuit of these cases are not usually just primarily, and maybe primarily to win the case and to obtain compensation for harm suffered, but there are many sort of side objectives that the people bringing these cases try to pursue. And one of these objectives, of course, is also to create some transparency and also socio-political debate in the Western societies where these cases are brought before courts. So basically to raise some questions there about the actual costs of our prosperity, about the actual bill related to the activities of our multinational corporations elsewhere. And I think when you talk about these so we're not talking about basically any legal aspects anymore, but the sort of the socio-political context in that context, and I think that context is really important because these cases are not just about getting money, about winning. These cases are about raising an issue, about bringing a very important and big issue to a larger audience. And I think in that respect, framing a case as a human rights related case may have added value. And I think there is some research also in the economic field and perhaps also in the social sciences field that I don't know, I would be very interested, that shows that perhaps framing cases as a human rights case means that it may have more of a societal impact. So I'm not talking about the legal, but more of a societal impact, that investors will be more easily moved to disinvest if it's a human rights a case framed as a human rights related case than in other cases. And I think it's really important, perhaps for us, but at least for me, this is one of the things that I want to do, to look into also that aspect of these cases. And because I think, and the Dutch case of Kiobel versus Shell, to get back to that as a final note, that was initiated last year, the choice to base this case on human rights law, Nigerian human rights law, has been a very conscious choice because I asked the lawyer, and bringing the case. And because what she said is that in this case, actually it was easy because principle had, framing it as a human rights related case out of principle and legal pragmatism actually went hand in hand because they felt that their prospects for bringing the case would be better if they based it on Nigerian human rights law than if they would base it on Nigerian tort law. But also the desire by the people behind the claim, so basically Esther Kiobel, the widow of the environmental activist Barinam Kiobel, so that went hand in hand with the fact that she actually wanted also the case to be brought as a human rights related case. So in this case, it was actually easy. It went hand in hand, and they decided to frame it as a human rights related case. But I think in many cases, principle and pragmatism will not go in the same direction, and I think it's really interesting to consider reasons for going one way or the other. And I would be very interested to hear any views that you might have on this topic. Thank you very much for your attention.
Thank you very much, Liesbeth, for what in my reading is a very clear perspective on the potential of litigation. Litigation in transnational cases, and in a very pointed manner also bringing up the issue of the pros and cons of framing cases from the perspective of human rights and human rights law. We then move on to Nicola Jegers, University of Tilburg law faculty, who will share her ideas about the potential of the Sustainable Development Goals, or maybe the lack of potential of the Sustainable Development Goals and the business and human rights discourse, ships passing in the night.
Thank you, Karen, and thank you to the organizers for inviting me here today. That was a very interesting presentation by Liesbeth, and I'm very tempted to jump in and react, but that's not what I'm here for, but it does relate to what I'm going to be saying here today, because I think the core of the matter, what I'm going to try to bring across here, is that language matters. Language is extremely important. And so no doubt we'll get back to that. But I'm very happy with the opportunity to present my paper, which I gave the title Sustainable Development Goals and the Business and Human Rights Discourse, Ships Passing in the Night. And back in 2005, Philip Alston, famous human rights scholar, published an article in the Human Rights Quarterly using the same metaphor of ships passing in the night. And what he did, he analyzed the state of the human rights and development debate through the lens of the Millennium Development Goals. And he reached the conclusion that even though both agendas were heading in the same direction, neither communities really embraced the linkages and the opportunities. And according to Alston, the MDGs were extremely important, and he stressed and called upon the human rights community to engage much more effectively with the development agenda. So today, the picture seems quite different. If we're looking at the current most prominent initiative in development, the Agenda 2030 with the Sustainable Development Goals, it's a different picture. So the UN has set a really ambitious agenda with Agenda 2030 with the 17 development goals, which promise to leave no one behind. And the human rights community, when we compare it to the Millennium Development Goals, have started to engage much more actively with the SDGs, with the Sustainable Development